I think we should begin. We have a long and interesting 2 hours. We have speakers who I think you'll find stimulating, and I don't want to waste a minute. Contrary to appearances, despite this chair, I am not the Emperor Qianlong. I don't know where this came from, but I can assure you it's comfortable. Second, I just want to say a word about the late Tim Gelatt. He was a terrific student of mine. He was a very fine scholar. He was a wonderful lawyer. We worked together for a while in the same law firm. He taught here as an adjunct for a number of years, long before I got here. He was a scholar and a human rights activist. He wrote about commercial subjects, legal institutions in China, but he wrote an equal number of articles about the state security law, China, and human rights. He negotiated contracts in French as well as Chinese and English, and he died at 39 on the streets of Greenwich Village. So the program is simply to try in an appropriate way to recall his contributions. We're very lucky today that our scheduling, through blind luck, coincides with the end of the 4-day plenary session of the Chinese Communist Party held in Beijing. Until today, there was no news coming out of the first 3 days, but now the communique, the report, is out. And while people who were looking for a stunning departure, a new policy in China's economic development, have been disappointed that the plenum's text does not seem to offer much in the way of guidance, certainly very little detail about a new development in economic policy. The words for the lawyers are better, a little bit, modestly better than we anticipated. In the run-up to the conference, very little was said about law. It was all about economics and the great expectations that the conference generated. But now people are noticing, well, there are some other things in there, and what they've said about law seems to end the debate about whether people should pay attention to China's constitution. They should, according to the communique, albeit the socialist constitution. And it emphasizes the importance of independent court adjudication. What that means, of course, is subject to a good deal of speculation, if not cynicism. But it's worth looking at this report. I suppose tomorrow's newspapers will have the text in English. Now, whatever the result of this third plenum, I think it's clear China's impact on the world is going to continue. Whatever China's development encounters, smooth progress or otherwise, more and more people know China is affecting the world's economy, its politics, international relations, and increasingly international law. Now, we have on our program today people who are equipped to talk about at least some of these aspects, because inevitably, as China has made an increasing mark on the world, it's obvious that more and more of our faculty are getting involved. And you'll see this when we talk about economic matters, foreign direct investment, WTO. Antitrust has raised its head in China and already begun to make an impact on American and other foreign business. Environment, we're exposed to every day. Some of the difficulties Beijing has just gone through, as some of you know, another very difficult period. And that may be the greatest human right of all, except for perhaps the right to avoid nuclear extermination. conventionally looked at, China's human rights matters are very, very important. We'll hear about that too. So I think this is an occasion to at least take a sort of view a roster of some of our faculty. There are many others who have become involved with China. We couldn't put them all on in one program. But we have an interesting group, and I don't want to delay further. And we thought we'd use an informal format, asking each of our speakers to respond to a similar set of questions. How do they perceive China? What's their involvement been? What might we be doing at NYU, students as well as faculty, to expand and strengthen our engagement with China? So those are the questions. I thought I'd start. We're going alphabetically with Professor Alvarez. Jose Alvarez has been president of the American Society of International Law. He's co-editor with another of our colleagues of the American Journal of International Law. He's just put out a distinguished book relating to foreign direct investment. And most importantly, for our purposes, he has just spent some time in China. So Jose, why don't you tell us, you're a newcomer to China. What are your impressions? I personally think China may be on the verge of a third stage of international law, but I want to hear what you think. How are you processing this into your computer?
So, thank you. This is the first time I've been brought in as a pseudo-Chinese expert, and it's a new experience.
In China, everything is fake now anyhow.
So I was invited to do the general course in something called the Xiamen Academy of International Law in Xiamen, China. And I think it's quite revealing of China's aspirations, that what it did was replicate the Chinese equivalent of the Hague Academy of International Law in China. And it's copied down to the fact that all the courses over the course of 5 weeks are taught by folks mostly from outside of China, just like they would be in The Hague, outside of The Hague. It's all done in English, although in The Hague it's split between English and French, and the Chinese have basically said, no, we think you guys won. The language of diplomacy is English, and we're content to adopt it for this purpose. And so what the purpose of the course is to train a new generation of both scholars and young folks studying law in international law. And in preparation for that, I looked at things like the equivalent set of lectures given at the Hague Academy by the now Chinese judge on the World Court, Judge Xu. And her title was Chinese Contemporary Perspectives on International Law. And based on what I saw, I think it was fairly accurate. This is a country that's come from an initial quite hostile approach for totally understandable reasons, especially during the 19th century, everything that they had suffered from the hands of the West, at least as they perceived it, a posture that was hostile to international law, to now basically being a part of virtually every international organization that I can think of, becoming now not just a defendant state, but a more aggressive state that brings claims in the WTO, including on antitrust. That's fairly new. A veto-wielding state in the Security Council that now can act as a brake, as it sees it, to things like R2P, responsibility to protect, or a more hated concept, I think, in China called humanitarian intervention. And I think it has drawn lessons from the Libya experience, for instance. And in what is also fascinating to me is that in some respects, China is acquiring the knowledge of and the expertise of being a great power using international law for its purposes. So that in some respects, it reminds me of another exceptional nation that also treats international law in the same respect. So that when you look at the US and China on many issues that I follow, there are parallels that are quite striking. So with respect to the investment regime that you mentioned, Chinese bilateral investment policy is relatively consistent with the United States. It has followed the U.S. model bilateral investment treaty by a lag of a few years, so that now, just like the United States, it's making sure that those treaties continue to protect investors, but also protect regulatory space for the state, which also reflects what the U.S. has now learned, having been a defendant state in the NAFTA for more than a decade. So that on BIT policy, and of course many people in this room know the U.S. and China are negotiating a bilateral investment treaty, and on the face of their respective model treaties, you would think that that is actually feasible. It's the politics, I think, that will get in the way of that. But also on counterterrorism policy, China is at least as concerned, albeit for somewhat different reasons. And on cybersecurity, an issue that emerged while I was lecturing in China was Mr. Snowden. And there was a bit of glee around the room to discover that the state that had been pushing no governance on the internet and freedom of the internet was now learning that there's a price to be paid. And several of the students thought that perhaps we would come around to protecting cybersecurity in the same way that China believes is necessary. There are obviously clear differences on a number of things, but for example, on the last thing I'll mention that is similar is China's approach to international dispute settlement. Both the United States and China are not parties of the compulsory jurisdiction of the World Court. Both of them have judges on that court, but are usually there only voluntarily or because somebody accidentally bumped into an old treaty in which we subscribe to the court, but it's certainly not either their policy or ours to sign treaties that go to the ICJ. Neither state is a party to the International Criminal Court and has stayed a bit of a distance from that. Neither are parties to any international human rights court. And the only areas where they subscribe to international dispute settlement are actually the same, the WTO and investor state arbitration. So that on that concept of exposing yourself to supranational scrutiny by international judges or arbitrators, the policies of the two nations are surprisingly congruent. So those are some of the reasons that I think we have to look at China. Obviously, it is a state that is important because, as one of my colleagues put it on the way here, it's big. That is, we're talking about 20% of the world's population, the second largest economy, soon to be first, a regional player that is competing with us on many levels, including with respect to the other area that I follow, which is the Trans-Pacific Partnership, where China is creating, as great big states do, rival forums for things like that. So it's beginning the trajectory of not just being comfortable in international organizations, but actually shaping them. And I think we're at an important moment for that respect.
What do you think we ought to be doing to enhance our ties to China internationally?
Well, the easy thing, I think, but it's not as easy as it appears, would be to enhance academic engagement. But I'm also on the committee for the University Committee on the Global Impact that was created as a consequence of some of the controversies associated with our portal campuses in Abu Dhabi and in Shanghai. And there are some very tricky issues here, including the whole question of academic freedom in both places, not just China. But there is talk, for example, that, of course, there will be no interference in how and what we teach when we're in China. And I found that to be true. I could say anything in that classroom. And it was over 120 students, including some from Taiwan and from 20 other countries as well. But where the line may be drawn, and I'm not sure how that is done, is research. So that it is possible that some of our students may be constrained in the types of research, especially if they expect to publish while in China and especially if they want to publish in Chinese. And that's going to be a serious question.
Well, that's a good warning. China, of course, has come such a long way with respect to international law since the PRC entered the UN in October '71. The following year, I was lucky enough to have dinner with Zhou Enlai, as some of you know, and after a few hours, I got my nerve up. I said, now that you're in the UN, you should put someone on the International Court of Justice. And the group around the table laughed furiously. They thought I was a comedian. China put someone on the ICJ? It seemed ludicrous. That bourgeois, imperialist group of people, anti-Asian, etc., how could we trust them? I said, it's a perk of being a big power. You're going to want to do that. Took them 10 more years, but ever since, as Professor Alvarez has said, they have very competent people. Ms. Xue, who's a Columbia Law School graduate.
An SJD from Columbia.
Pardon?
An SJD from Columbia.
Yes, she got her doctorate. Were you there at Columbia? I don't think so.
No,
I
we
think
did
it
not
preceded you. You're a young
But
fellow.
she was trained by Oscar Schachter, one of the leading
Yeah.
lights in international law. She totally understands the concepts.
They now have expertise not only in international law, but in every field of law. Most we'll hear from others to what extent. That's very impressive. Well, next alphabetically is our dear new colleague, Ira Belkin. Ira has, before he came to NYU to get his JD, he was a teacher of Chinese, if you can believe it, at Middlebury. He's been feasting on that ever since in terms of his classmates and students and others. But he was a federal prosecutor for 16 years, and then he decided to go with the true faith, and he went out and became legal advisor to the American Embassy in China for 5 years, and then the Ford Foundation's legal advisor in China. And we're lucky to get him. He came here a little over a year ago and has injected a lot of life into our programs. Ira, tell us something about criminal justice.
Well, I want to thank you, Jerry, and I want to thank all of our colleagues for participating in this panel today. And I think just looking at the program, it answers the question that we've asked. Why should we care about the Chinese legal system? I'll talk a little bit about criminal justice, but first, I just wanted to bring this to a little bit of a personal level. When I was a student here, and some of my classmates are in the audience, class of 1982, which I like to joke is towards the end of the Qing dynasty. There were only a couple of us who acknowledged our interest in China, but if you did it too publicly, people would think you were a little strange. Of course, Jerry's interest in China goes back even further than mine, but as far as NYU was concerned at that time, NYU hadn't yet developed a global outlook. We're still very much a national law school, and the idea of caring about what was happening in China just seemed so remote and so out of the mainstream. This was before Jerry Cohen came to NYU. It was before we had a U.S. Asia Law Institute and courses about China, and before we had so many students from China. Now, fast forward all of these years to 2013, and as I said to the dean when he hired me, I don't think any graduate from NYU Law School, if they stay in the legal profession, will have a career that is not in some way impacted by China. It doesn't matter whether you're studying antitrust law, securities law, criminal justice, international law, of course, any field of law, one way or another, China will impact what you're doing, whether you want it to or not. I just took a quick, extremely informal mental survey of my classmates from 1982, and well, one of them is here, Spencer Griffiths, who's an international trade lawyer. One of our classmates has owned a coal mine in China. Another one is negotiating to buy a Dutch seed company that owns greenhouses in China, and he's worried about how China will treat the intellectual property of the seeds grown in China. We have another classmate who's been practicing in Taiwan for several decades. There's just no question that China's important, no matter what field of law you're in. Now, if you're in the business field, then it's almost impossible not to be involved in China in some way, either as an investor or a partner. And so, of course, you're concerned about the Chinese legal system and whether or not your interests and rights would be protected adequately in that system. You may be an investor in a patent that's part of some international standard, which could be affected by a judgment of a Chinese court. There's just so many ways. We also are seeing something now called the China model, that the rest of the world, especially the developing world, is looking at China and sees China's economic prosperity and is asking itself whether they should follow China's path to development as opposed to the Western path of development. And China is actively promoting its model and actively investing in resource extraction all over the world. So what China's doing in China is not only affecting the Chinese people, but it's really affecting everyone in the world. And so we have to try to understand what's going on in China better than we are. We have to invest resources, human resources, in trying to understand the Chinese legal system. The other thing about China is it's not easily accessible to us. Yes, we can travel to China easily now, but because their political system and their legal system is so different, oftentimes, even if they use the same words, they don't mean the same things. And their legal system is embedded in a political system that, to us as Americans, is very strange and very difficult to get a handle on. As Jerry just said, we've seen announcements coming out of this third plenum of the party about independent adjudication. Translation's always a problem. 独立刑事审判权, as opposed to an independent judiciary. A few months ago, we saw a document that was publicized that, according to the document, forbids discussion, public discussion about an independent judiciary, among other things. So how do we understand what this means? And it's important for us to understand what it means. So I just want to spend a couple of minutes talking about our U.S. Asia Law Institute and who we are and what we do. Because our resources here at NYU compared to when I was a student here are just tremendous if you're interested in China, as of course I think everyone should be. So we are a group of people who are a group of lawyers who are bilingual, bicultural. Most of our staff has degrees from Chinese law schools as well as this law school. Many are licensed to practice in China as well as here. And so we pride ourselves on being a bridge between our two systems and between trying to help Americans understand China and trying to help Chinese understand the U.S. But that's not all we do. We actively participate in legal reform in China. And we work in several different areas, and we hope to expand our work. Traditionally, we've worked in criminal justice reform, as Jerry has said. And when we talk about some of the programs we've done, a lot of people are surprised that we're able to do this, but we have good, long-standing relationships with partners in China. We take a problem-solving approach to legal reform, and I'll just give you one example of a recent program we did as an illustration. We had Professor Schaefer come with us. Jim Jacobs has come with us in the past. We focused on how to prevent torture in police interrogations. And the Chinese have done a lot in their criminal procedure law to try to address this problem. We also recognize we've had a problem historically and even presently with false confessions and wrongful convictions. So we brought a group of experts, not just from the US, but also from the United Kingdom and Australia. The United Kingdom and Commonwealth countries have generally done better than we have in this area. We also brought experts from Taiwan. And Taiwan has been involved in this legal reform process and criminal justice reform process for several decades and has a lot of good experience to share with folks in China. And so we addressed the problem that every system has to some extent, and what's the best learning that we have. We also brought with us a film that probably some of you are familiar with called The Central Park Five, that dramatically shows how an innocent person might come to confess to a crime that they never committed. It's an American case. Our staff worked with the producers to put Chinese subtitles on it, and it illustrated the problem in a way that it's just quite different and more dramatic than just talking about it can. And we got a very good reception from our Chinese audiences. With the help of Professor Schaefer and and Judge Marty Marcus from the Supreme Court in the Bronx, we demonstrated a suppression hearing under U.S. law, and we asked our Chinese colleagues to demonstrate a suppression hearing under the new Chinese law. So we had a very deep exchange on this very specific issue, and we hope we made a difference. I think if we look back historically on the work that we've done, we have made a difference in criminal justice reform in China.
What impressed me about that program was we had 300 prosecutors from all over China who were specialists in pretrial interrogation and investigation. And that was real impact. And we were reaching out not just to judges or lawyers, as we normally do, and law professors, but to prosecutors. And we're beginning to reach out to police. So we're making progress. But now I want to turn to Professor Eleanor Fox. It was a great pleasure and surprise when I learned that Eleanor Fox on her own was making contact with the antitrust experts of China. And lo and behold, she then produced an excellent article about where China is heading. Eleanor did not grow up studying Chinese. She became an expert in antitrust law, competition law, not only in the United States, but also in Europe. But here she was extending her reach to China, and it seemed to me she was a kind of emblematic example of a faculty person being drawn into the Chinese net and cooperating with them. But Eleanor, tell us your perceptions of antitrust law in China and what we are doing about it and might be doing about it.
Okay, thank you very much, and it's very nice to be here today. Let me start out with the third plenum and a line that's been in the press, at least the virtual press, this afternoon. One of the big issues in the third plenum was about how much more China should move towards markets, because China is perceiving that with more markets, it will probably get greater growth and more efficiency. And the counterweight to that is, and how much more government control, as between the state and the market, how much more market, how much government control. So one of the lines that's in the press this afternoon is to say that Xi Jinping has said we need more markets. We also need more government control. China has, as you probably know, a great number of state-owned enterprises, and that is government control because the state controls the state-owned enterprises. But these state-owned enterprises also engage in the market, so China wants to keep nurturing the state-owned enterprises, and at the same time, it is saying we need more markets. So that is a statement with two sides that might be somewhat conflicting with each other.
Something for everybody.
Something for everybody. Everybody wins. I wanted to talk about that problem of state and market because that's how I get to China. Because my field is antitrust, and antitrust is about markets, and it's about the extent to which the law controls, limits the extent to which companies may try to exercise market power in markets. So virtually every country that has moved to a market system has adopted a competition law going hand in hand with markets and trying to make markets work better. I went to China for my second time on my sabbatical in 2006. This was 2 years, well, 1 year before China adopted It's modern competition law, and 2 years before that law went into effect. And why did I go to China, Jerry? Because China was there. You cannot not go to China. And I have to say today, since China has adopted its competition law, if any of you, which is the same as an antitrust law, if any of you are in the antitrust field or students are budding antitrust lawyers, you must be interested in China, because China has become one of the biggest players in the competition world. As you know, competition is not local anymore. Many transactions are international. Big mergers have to get cleared in about 50 different jurisdictions, but there are only a couple or a few that really count. And of the 3 that really, really count, it's United States, European Union, and China. So I went to China in 2006, and I was hosted by a couple of universities, and I was ushered into a big auditorium, and there were hundreds of mostly graduate students, some faculty, who were very interested in competition, and before the competition law went into effect. And I was absolutely amazed. And we had a session, a lecture, and questions and answers. Their questions were so interesting and almost always involved something about industrial policy, which I'll say another word about in a minute. And I did ask a number of people while I was there on that trip, saying first that I was, of course, so happy and interested to see such a great interest in the field of competition, which, as I say, is also the field of markets. And how do they explain this when it's not even a field yet in China? And the explanation that I got ad hoc from several different people was to say, we really think that if there is more ability to engage in the economic enterprise of individuals to choose what they want to do, to make their businesses, to engage in the field so that there are vibrant markets that enable people to be in them, that this may be a counterbalance that pushes back some autocratic motivations. So seeing competition and markets and the freedom to engage in markets as a possibly countervailing power against too much government power. So I went to China again this year about 6 months ago, and I will go again in January, and I'll go again in May. Once you go, you cannot keep away, I think. And of course, when I went this year, of course I found so many people who were very interested in the field and engaged in the field, and engaged sometimes not only in the technical field, but also, this relates to some professors, also in trying to get legal system reform. And it's been a great experience for me to work with individuals in China, both the faculty and the students and the agencies. The competition law in China is enforced by 3 different agencies, one for mergers, one for price offenses, price-fixing type offenses and monopolistic practices, and another for other practices that are not price-related. I've met with people in all the agencies. I've had very cordial meetings. I felt, and I do feel, these are very professional people. They're really trying to do their best. They're not trying to favor the Chinese enterprises over the foreign enterprises, although this, I have to say, is a constant tone that you will get from Americans especially, and Europeans too, maybe partly paranoid, I don't know, but feeling discrimination in the application of the law. So I feel these are really good, smart professionals. I averted to the fact that if you're a merger lawyer, you really need to, and doing antitrust, but somebody doing the mergers has to do antitrust, you really need to take account of China because it is a force and a big player. There is a complaint constantly made by the lawyers who are filing their mergers with China, which is that China is the slowest jurisdiction in clearing a merger, even a merger that on the face of it has no competition problems at all. And sometimes I hear they think it's because China's against foreigners trying to hold up their deals. The fact of the matter is that China's staff at MOFCOM, that's the merger agency, is about 10 or 12 people are the case handlers, and in the United States and Europe, it's about 120 are the case handlers, the lawyers, and the economists. They have a very thin staff, and they're very well trained, and they're trying to do the best they can, but these agencies are not independent. MOFCOM is a weak ministry. MOFCOM has to listen to the very powerful ministries. NDRC might say to MOFCOM, well, no, we really don't want Coca-Cola to acquire Huiyuan juice because Huiyuan juice has one of the strongest brand names in China, they might say, although this has not been publicized this way, but some people read it between the lines, and we don't want a wonderful Chinese brand to be in the hands of the foreigners. So if NDRC does give some advice or instructions to MOFCOM, MOFCOM will have to take that advice into account, and it will come out with what looks like an antitrust decision to the extent that they publish the opinion, and they really only will publish a very sketchy summary of it. It will look like an antitrust opinion, but in several of them one might detect there are some responses to pressures that don't look like they're exactly antitrust. They might be keeping crown assets in China. A recent clearance of Gencor Extrata was an imposition of conditions, so they produce a lot of minerals, especially copper, on which China relies, and there are conditions that China imposed on the merger that will be sure that the Chinese keep this source of supply for many years, and that is not particularly related to what one would normally think would be an antitrust problem. So one does know that these merger decisions that do come out of MOFCOM might possibly be tweaked a bit by industrial policy. That is not to say that other countries there is industrial policy.
Well, you are a mistress of understatement. I think this is a problem in every field dealing with China. You often are dealing with a competent but weak agency, and that agency has to respond to broader and higher demands, often tinged by politics and other considerations. But we can come back to that. I thank you very much. This was interesting. One of the many pleasures of going to China for the training programs that Ira identified is that we have occasional possibilities for asking our colleagues to join us. And Jim Jacobs has gone on many trips, not only to mainland China, but also to Taiwan. Jim is head of the NYU Law School Center for Research in Crime and Justice, professor of criminal law and procedure, and a splendid companion who has been, from the outset of our U.S. Asia Law Institute, our strongest supporter. So I'm eager to hear what he thinks about his many trips to China and what we might be doing in the future. He's always trying to disabuse me of the notion that things in our criminal justice system work according to what the printed page tells us. Most recently at lunchtime today, we heard about the realities of the Bronx criminal court system. And after he got through with our guests telling us about that, I began to think, maybe the Chinese criminal justice system is better than I thought it was.
There's probably truth to that. So it's all been a pleasure. It's been a great part of my life here at the law school for the last 10 or 15 years to be associated with the East Asia Institute and with Ira and Jerry and Frank and the others who've been here. So I've benefited greatly. I did want to say at the outset, I also knew Tim Gelatt when I came to the law school, and remember him as a very fine person, and it was a tragic loss. And Jerry said that he died on the streets of Greenwich Village, so I'm sure some of you winced and had a picture of him being murdered, but that was not the case. He died of tragic natural causes.
He had a brain aneurysm.
Yeah, so wouldn't want to leave that impression, but he was marvelous. So I have been to China on various trips with Jerry and a few without Jerry, and a couple to Taiwan as well. And a lot of our experiences has been talking about American criminal justice, American procedure, and American issues, and kind of informing the Chinese audiences. And I've enjoyed doing that, and I've enjoyed answering the questions. I also have learned some things about China and Chinese criminal justice. But I think it is much harder, especially if you are an empiricist, as I am. I'm not so interested in the specifics of what the Chinese code says, which also is difficult to interpret because of the words and the differences in the legal cultures and institutions. What are the police in China compared to the police here? What is a judge compared to, that stuff is, the more you know, the more you realize you don't know. But I am always interested in how things are actually working, and the difference between the law on the books and the law in action. I think that a lot of American lawyers do not know how the law on the ground works in the United States. It's not an easy task to know that. We're a very big country, and there are tremendous differences from place to place, differences from our federal system to our state systems, differences from New Orleans to San Francisco and so forth. So in a sense, we're always involved in trying to learn about how things are working, even in the United States, and learning about experiments in, say, in pretrial detention or in pretrial diversions in prisons and jails in one part of the country, and how it translates to something else. And in talking, I think a lot to the Chinese hosts and participants in various conferences, I'm not sure how much they really know about what is going on the ground in China. People may have, they see things from where they are, but it's a very big country, and there's a lot of differences. And of course, the police and the functionaries and the prosecutors see things with different eyes. So in thinking about what we would like to do in the future, I certainly would like to learn more about what is happening in the institutions, like the pretrial detentions, and in the prisons, and in the courts, and in mediation, and so forth, and how much variation there is across the country. My impression is that kind of empirical inquiry in China is not well developed. There's not a great, I think, academic tradition of criminology and criminal justice studies. So it's been fun meeting people who come here to learn, and talking with them about the kinds of research projects that they might do. And I think it may well be that the next generation in China will be much more empirically based than they are now. But the debate now is very much over the wording of legal documents rather than the shaping maybe of legal institutions. Another observation I would have about China is the absence of the kind of data that we take for granted here. You know, we have all kinds of crime statistics. We're drowning in crime statistics. We count a lot of things. And I think we have a pretty good informational infrastructure in the crime and justice area that we may even take for granted. And we don't have that, I don't think, that kind of informational infrastructure in China, so that even basic data are not available, and therefore, you know, it's difficult to do empirical research. So I think we could be helpful, and in being involved in various kinds of projects like on building a more empirically based criminal justice a set of inquiries. I think that we want to engage with the Chinese, and I'd like to see us do more on how we approach common problems. I think that would be very stimulating. And there are so many different kinds of problems that you can think of, substantive criminal law problems like what do we do about drug abuse, and what are the issues that we're facing, and where are the debates going on in China and in the U.S., and what are, you know, the different experiments and the different sides of that. I think corruption is another issue that is very important. We certainly don't have a handle on it in the United States. We have a lot of corruption issues and a lot to talk about with our Chinese counterparts, and to see how they're thinking about it. Maybe the most interesting trip that I had to China was the very first one, where we went to talk with people who were setting up the first stock market in China, and were interested in regulation and the role of criminal law in that regulation, and you know, and are talking about our experience in regulating the securities markets, and this, what I thought, and the others, our successes and failures and challenges, and they're also thinking about how can we get this right, and it felt more like working on common problems. So I would like to do that, and I have also one pet idea, is that we ought to be able to figure out an extradition treaty between China and the United States, and you know, it's really quite fascinating to me that you know, Americans, we can't extradite people to China because they don't have, you know, the kinds of rights that we have, the kind of rights that you wouldn't see if you went to the Bronx and watched, you know, 100 cases. You wouldn't know what people were talking about, you know, and the Chinese won't extradite to us because of our system, and so we have crime. You know, criminals can get safe haven in the other country. I mean, it really strikes me as ridiculous, and we have I think have had increasing improvements in cooperation on criminal issues, especially below the surface, and I would like to see that develop. Just one more point is that I did have a couple of trips to Taiwan. It was a different kind of experience in Taiwan. For those of you who've been there, I mean, Taiwan is a much more Western, much more familiar to a Western person than going to mainland China. A lot of the people in Taiwan are have been trained in the U.S. There's a lot more of English. There's a lot more criminologists. With the last time I was there, not so long ago, we talked about a lot of common problems like forfeiture law and civil forfeiture and criminal forfeiture, and what their problems are, and they've got, you know, and our problems are, and I think it was very exciting, very interesting, very exciting watching a new democracy evolve like that. And a lot of interesting people. I got to visit a prison, which and not just a model prison, but a real prison, and I thought that was sobering, and talked about prison overcrowding like we have here and so forth. So it's all really interesting, and I think we bring it back into the classroom. It always makes you think about how we're doing things, and I look forward to more trips and more interactions.
Thanks, Jim. China is pressing us for an extradition treaty. So many Chinese bankers and business people have absconded with billions of dollars to the United States, Canada, and other places. The Chinese government is eager to get more cooperation in getting them back to China. And of course, the United States, for political and legal reasons, is concerned about agreeing to extradite people in view of the vagaries of the Chinese justice system. Fortunately, as Jim implies, China thinks better of our legal system than many of our own experts do. They're less familiar, despite the fact we're so transparent. But that's the other point worth mentioning. There's a struggle in China today, as many of you know, over transparency, over the internet. How public can information be? How far should state secrets go in the government application? And this is part of the continuing struggle. Well, one of the subjects that Chinese have not been able to keep from public view is the environment. And I remember I was a Supreme Court law clerk in 1955 term, if you can believe it, and the court had turned down a petition for certiorari from the first conviction in Los Angeles for violating the anti-smog ordinance. And on a petition for rehearing, the upset petitioner, having been denied before, said, you can't not decide this case because otherwise you leave the whole question of smog up in the air. Well, in China, it's up in the air for everybody to see. And we've seen some vivid photographs, and I've personally, as many of you must have experienced, even the inability to land a plane when things are really bad in December, etc. We're lucky to have with us on our faculty one of the really great experts on international environmental law, as well as our domestic and international administrative law, Professor Richard Stewart. And he's had an interest in China for many decades. I remember he visited me in my Peking hotel office in 1981. I think it was when he was out for the first time to give a couple of weeks of lectures to the Chinese about international and environmental law. He'd never been there before. And fresh from his last lecture, he said to me, Chinese are really great people, he said. Where else in the world could you go and give people free 2 weeks of your time and lectures, and then they say to you at the thanking departure banquet, if you play your cards right, we might let you do it again. And he's done it many times in China, and I want to hear about his own thoughts about China and the environment, because no problem is more urgent.
Thank you, Jerry. As Jerry says, I first went to China in the early 80s. Things were very primitive indeed. There were, no cars to speak of, except for the party elite and a few taxi cabs that actually took us around. I thought at least they're paying for the taxi cab. And we get into the car to go to the airport, and they give us the bill for the taxi cabs too. So, buses, trucks, and millions of bicycles. Well, I went back in the mid-'90s for a number of years on a project that, with Jerry's help, we got funding from the Asian Development Bank to help train the staff of the new Environmental Protection Committee of the National People's Congress. They thought, well, we need committees to have specialized knowledge in particular areas of legislation like foreign taxation, foreign investment, and environment is a new issue. So they recognized that, and they had some very good people. And so we worked on some revisions of their laws with training sessions in Beijing, but also here in New York and in Washington, meeting with, brought the drafters and some people, officials from the ministries to meet with government officials, with NGOs, et cetera. And then I've been back again several times in more recent years. And as I look back, I say it's just astonishing development and growth. When my wife is an environmental lawyer, and she was involved in this project with the National People's Congress, and we went back in 1993, I think, and we staying at the Friendship Hotel, which was part of the Soviet complex originally, and I'd stayed at in 1982, and there were cockroaches every place, and went back, and some travel people in Beijing said, well, we're staying at the Friendship Hotel. I said, not again. It was a 5-star hotel, right? And we took our daughter, and my wife said, we have to take Pampers, and she was 11 months old. And I said, I'm sure they have that in China now. Well, we took all the stuff. But I got to the hotel, I said, is there something like a department store nearby? Down on the corner, there's like a Sears Roebuck. You get electronics, you know, clothing, good, not super quality, Pampers, you know, baby food. And I said, this is what the party is doing for the urban middle class, right? Economic development. Deng Xiaoping, a socialist market economy, seems to be working. And then, of course, you go back more recently, and the development is astonishing, the number of cars. So you can say this is contributing in some aspects of the quality of life in such dramatic terms, at least for the urban middle and upper class, right? But the environment has gotten steadily worse every time I've been, right? And sort of how can this, and now it's getting to be, you know, a very, very, very serious problem. It's been serious in various ways in the past, but now the air pollution is astonishing, and some of the water pollution, including drinking water supplies. So how is this paradox of all this growing prosperity and a worse environment? Well, it goes back, I think, to you know, Deng Xiaoping, socialist market economy, but forgot that under Marxist dogma, you know, pollution is a capitalist disease because firms in the market have to compete with one another, and they can't voluntarily limit their emissions. Of course, we also know that pollution is a socialist disease as well, when powerful big ministries involved in development have the main say, and environmental considerations are secondary. But so we moved towards a market economy, but did not set up the legal and administrative infrastructure you need to regulate the market. And so there's a huge gap. There was some regulation, maybe not terribly effective. Before, though, as I learned, the environment ministries had a role. They had to check off when you built a new plant, you got your money from the government to build it, you had to check off, yes, we're installing this and this pollution control device and so forth. So at least there was some control, but then firms started going to the market to finance, and there was no adequate regulation in terms of either the laws on the books, and then especially in terms of the legal and administrative infrastructure. And, and of course, this is exacerbated in China because of the vast size, diversity of the country, and the highly decentralized system of administration. We're in a situation today when I think increasingly people in Beijing, don't know what's going to come up with the new government, recognize that this is a problem that is compelling in terms of the economic costs, the health costs, the human capital costs, and yet they don't have the wherewithal in terms of laws and infrastructure to transmit the right sort of incentives and controls down to the provinces, to the municipalities, et cetera, et cetera. And so we tried to do some work in this law drafting. There's a lot to be done there, but also building up the legal and administrative system. And I am particularly concerned about climate change. And a lot of this prosperity has been fueled by coal, right? Coal-fired generation, new coal-fired plants at a staggering level. China has now, of course, far surpassed the United States as the leading greenhouse gas emitter. Over half of our mercury pollution in the United States comes from China. So this is not just a Chinese problem. The European Union is regulating greenhouse gases. The U.S. is, thanks to the Supreme Court, beginning to regulate greenhouse gases under our Clean Air Act. What will it take to get China into this? Well, what it's going to take is going to get them attention to local pollution problems, the health problems in China, and if they can control the coal combustion to deal with these problems, it will have the side benefit of reducing greenhouse gases. And we talked about international law. Chinese are still, they respect international law, I think, and certainly in the environmental area. They don't want to make commitments about limitations unless they have confidence that they can keep them. And the party leadership has said, we are unwilling to make commitments that at some point in the future might limit our economic growth. So this is, I think, the challenge at the top policy level, to persuade them step by step that they're going to take steps to limit these emissions for other reasons, and then eventually to be part of a global climate treaty. What can we do in the meantime? Well, I think we can continue to help the people in China that are trying to strengthen the laws and the infrastructure, to learn from experience in the U.S., from Europe, from some other developing countries. There's no one model, but we have gone through this and other regions, and there's much to learn. And we do see some progress. We have a colleague from Tsinghua who is here studying emissions trading, but it is a terribly urgent problem, and I can only hope the new leadership is more attuned to what needs to be done.
Thank you, Dick. Your emphasis on the huge changes and improvements over 30 years reminds me of foreign exchange. It's one of the most dramatic differences. When we first met in China, China was looking for foreign exchange. Everything that happened in China was interpreted. Would this help China's foreign exchange or not? And I remember, I think it was December 1980, the first time a foreign company was allowed to rent quarters, dining space in the Great Hall of the People, because they needed foreign exchange. Pan Am had a dinner to celebrate its first flight into China. And I was there sitting next to a vice minister of commerce. And in the middle of this very lively dinner came the tragic news that John Lennon had just been assassinated in New York. And that put a terrible damper on the party. And finally, the host tried to resurrect the atmosphere, and they started to try to say something appropriate to the sad news. And when he felt it was his turn to speak, the vice minister of foreign exchange, of commerce, said, "That man earned a lot of foreign exchange for his country." Well, look at the situation today, with China having this huge agglomeration of foreign exchange. And that's why I find it very perplexing. They still are skimping on the personnel required by the central government. They have, over 30 years, refused to hire enough trained personnel, whether they're talking about patents, trademarks, antitrust, whatever. And I think the central government simply needs to spend more for those purposes. A few less Mercedes-Benz might be in order, I don't know. Well, I remember many, many years ago, the leading specialist on Soviet law in the Western world was Columbia professor John N. Hazard. And he wrote a very lovely book. He was interested far beyond Soviet law. He wanted to know what the Soviet impact had been throughout the socialist world. And he wrote a very nice book called Socialists and Their World, I think. And Hazard has a chapter, the label of which is Property is the Key. And that has proved to be a long-lasting, wise insight. And in recent years, we've seen that property, the forced demolition of urban property, displacement of people who've lived there for decades, the forced acquisition of rural land so that the government could resell it to developers. These have been major causes of social turmoil in China. Fortunately, Professor Frank Upham, who has done very major work on Japan, law and society, including pollution, in recent years has returned to the only true faith, his initial study of China, and has been focusing on what's been going on in property. He's been teaching property in our law school for many years. And Frank, we welcome your perceptions and suggestions after many years of China watching.
Thank you, Jerry. I want to start by thanking the law firm of Aiken Gump, who has helped our financing for this program. So that's down at the bottom of your flyer. I just wanted to make that thank you. I don't know whether it's been done before, but I just want to thank them for their generosity. I wasn't planning on doing this, but I've known Jerry for 1970, so 43 years, I guess. I thought I'd heard all his stories. But the one about the foreign exchange and the one about the smog being up in the air, I haven't heard those. Or, of course, there is another possibility. I've heard them several times, but anyway. I also want to make an administrative announcement. Tomorrow there will be an orientation for the semester abroad programs. I don't know what the formal term is, for Paris, Buenos Aires, and Shanghai. The orientation is probably going to be in this room, and I think at 12:30, I'm not sure, but just a reminder of those of you who are students and are interested in spending a semester in Shanghai or any of these other two places, please attend. Property rights, yes. I'm interested in, says, why should we be interested in the Chinese legal system? Okay. I'm interested in the Chinese legal system for I guess, a couple of things, for what it can teach us about the process of development. And because, as Jerry said, I've taught property for many years, initially just because the law schools weren't willing to hire me unless I taught property. But over the decades, it's become the center of my intellectual and academic life. And so it's natural, I suppose, that when I look at China, I think about property rights. And because I've started to, partially because of China, teach a course called Law and Development, which is about the role that formal law plays or doesn't play in economic and other forms of development. That's one of the things that interests me about China. China has developed faster over a longer period of time than probably, this is a very difficult thing to measure, but probably any other society of significant size in human history. And it's done it with considerable success on the social side. I used to quote the figure of 300 million people brought out of the lowest level of poverty over the last 30 years. And then I heard Michael Posner, who has now joined Stern School for set up a Center on Human Rights and Business, but was in the Obama administration, the State Department on Human Rights, say that it's 600 million people. That seems high to me, but anyway, China has brought out more people from poverty than all the rest of the countries in the world in the last 30 years. In fact, if you take China out of that, the number of people who have gone into number of people in absolute poverty has increased over the years. So this is an economic and social, because they could have. China is a very unequal society, but not as unequal as we are. But it hasn't been able to recreate the Taiwanese and Japanese economic growth with a great deal of equality. So China is suffering from inequality, and that's part of what Jerry was talking about in terms of farmers' property rights and urban dwellers' property rights. But we have something to learn from that Chinese experience over the last 30 years. How has China developed, brought all these people out of poverty without a formal system of property rights? So one of the major currents in development economics is, of course, the priority of property rights. It is a matter of almost divine wisdom that you cannot have economic growth without secure property rights. China has proven that not to be the case. And so I think we have a responsibility to find out how that has occurred, not because I think it's going to help, the Rust Belt cities of the Middle West, the Midwest here, but because there are many countries in the world now who still have huge numbers of people in absolute poverty, and they could learn from, or they might be able to. It could be something that can't be replicated. I don't know. But we have the obligation, I think, to find that out. So one of the things that I'm very interested in is finding out exactly what kinds of institutions have been able to protect economic interests in China so that the market system can work as wonderfully as it has without the formal legal institutions that we all had presumed were necessary. So that's one of the things that I'm interested in. Another thing that, and that's sort of looking backward and trying to find out something that will be useful, not necessarily to do anything in China, but to help other countries develop at least in some of the same ways, or use some of the lessons of what I think it was Ira who mentioned, or somebody who mentioned the China model. I'm very happy to say that we at the U.S. Asia Law Institute are going to be having a program, and I hope more than one. We're going to have 3 workshops over the next 3 years on property rights issues in China. One of them will certainly be on this idea of informality. China has managed to have huge urbanization, huge economic growth, not by not having property markets, but by having illegal ones. And so that idea of informality is a very important one, and how China has been able to use that informality effectively when many other developing countries have not been able to achieve that. But the question now is, how can that informality, and this is something called small property rights, which are basically illegal property rights, informal property rights, versus big property rights, which are formally legal property rights. How can those illegal property interests be incorporated into the formal legal institutions? So in the city of Shenzhen, which is the 3rd or 4th largest city in China, 1/2 of the structures are illegal. Now, obviously, you're not just going to go in and evict people. So how is that process going to be done? Bring that into a formal, there is a vibrant market in these illegal property interests. The question is, how is that going to be brought into a formal legal market? This is a forward-looking thing, but it's also going to be very important for developing countries because, I mean, if China does it well, you know, if they screw it up, then I guess it will be a bad lesson, but I think they'll probably do it well. And that's an issue that faces all developing countries, or virtually all of them. As much as 80% of the urban residents in some parts of Latin America are living on land illegally. So how that transition occurs in China will give us some ideas of the ways that it can occur in other countries as well. So I think we have a great deal to learn from. It may not be the Chinese legal system, particularly because it's sort of extra legal, but at least the institutions that structure social behavior. We'll also, I hope, be looking at, in these workshops that the U.S. Asia Law Institute is going to be having, at affordable housing. And here again is something I think we should learn, or perhaps we can learn from China. I don't know. I want to learn whether we can learn from them. We certainly need affordable housing in the United States, and we certainly need it in New York. And China is doing a lot of efforts, mainly for people who have urban hukou, and that's another issue. And we hope to have a workshop on that where we can figure out what they're doing, particularly in Shanghai, because that's where NYU has its base. And we will be talking about what New York City, which I think among American local governments does more in the terms of affordable housing, housing for the poor, than any other major city. So that's what we're doing. I think these are common problems, like what Jim mentioned. We're way ahead temporally in most of these processes than where China is, but they're catching up fast, and I think we can learn a lot from them.
Thanks very much, Frank. One of the indicia that we've got from today's communique of the third plenary session of the Party Central Committee is that there is renewed support for a formal legal system in China, a formal court system. China has had this tension even before the establishment of the People's Republic, going back to the pre-1949 Jiefangchu, the liberated areas, between legal formality, legal institutions, and the masses participating in the administration of justice. And the shorthand reference for that has always been mediation, 调解. In the previous administration in China, mediation was getting quite a big play again. Informal third-party settlement of disputes, not going through a final court decision according to law necessarily, but by individuals, some of them court employees, judges even, but some not, people's mediators. That's been very important. Well, today's communique gives new support to those who want to see China build a more formal legal system. And for some of us, at least, that's good tidings. It's not to exclude mediation. I think one of the first articles I ever wrote about China in 1966 was about the traditional mediation system before the Republic of China was established, even in 1912. But it's a question of more or less and how much. Well, I want to congratulate my distinguished colleagues because they have shown militant revolutionary discipline in sticking within the allotted time. And that gives us quite a bit of time for discussion. And I'm hopeful we'll hear from many of you. Some of you, of course, are very well informed. Many of you are from China and some from Taiwan. And I was glad to hear Jim put in the plug for the importance of Taiwan in our study of China and our work with China, because that is another important aspect of what we're doing. Well, who would like to lead off? we could hear a word from our sponsor, as we say, Spencer Griffiths, whose law firm has been kind enough to support this enterprise. And you've been a lawyer in Beijing and in Washington. Would you like to say a word, your own impressions about cooperating with China in the future?
Sure, thank you, Jerry. My name is Spencer Griffith. Ira and I were classmates here at NYU, as Ira said, many years ago. When Ira and I graduated from here in 1982, Japan was trade enemy #1 to the United States. I'm an international trade lawyer, so I represent foreign companies and foreign governments fighting for access to U.S. markets and U.S. companies fighting for access to foreign markets. In my world, in the international trade arena, China is probably the focal point right now of further evolution of the world trading system for obvious reasons, kind of mirroring China's massive rise as an export power and its own massive domestic market. We're seeing pretty much now worldwide the trade debates focusing on China, U.S.-China relations, EU-China relations, Japan-China relations. And it's just absolutely central to our work as trade lawyers. A big moment, obviously, was when China joined the WTO in 2001. A lot of us and a lot of China experts thought, and I'm not a China expert, I'm a trade lawyer, unlike those on the panel, were concerned that China's entrance would sink the WTO, that China would politicize the WTO, turn it into a vehicle for airing fights from the developing world. From my perspective, I don't think that has happened. I think China's been pretty much a responsible member of the WTO. They're participating generally responsibly in the dispute settlement systems in Geneva, in the WTO. China has had members on the appellate body. China now has one of the 4 deputy director generals of the WTO, one of the 5 most senior positions in Geneva. So we're seeing China really playing a responsible role. In addition to China being such an important participant in Geneva and in the world trading system, it's obviously, for better or for worse, the #1 focus of trade fights worldwide. I saw some statistics just this week I checked. China has been the target of 5 times more trade cases, dumping cases, subsidy cases, safeguards cases in the last 20 years than any other country. 5 times more than any other country. And China is using the trade laws in its own right now. So those of us who are doing trade law, we're now representing U.S. clients and European clients, defending them against trade cases that China has filed against them. I'm involved now for a U.S. company in the solar panel fight. China has filed a case against the U.S. on polysilicon. So we're seeing a lot of movement on both sides on these trade cases. So I just think from the perspective of a trade lawyer, going back to Ira's point at the start of the panel, China has just been absolutely critical to anyone doing trade law. And obviously, those of you who are younger lawyers coming up, as I mentioned at a lunch talk at the Institute today, there's just a lot of work going forward in the trade arena for those interested in China as well. And one last comment, not only is China huge now, just in terms of number of cases, but all of the large, intellectually difficult trade and economic issues that the legal community is collectively facing going forward, so many of them involve China. The antitrust issues that Professor Fox was discussing, the AML, the anti-monopoly law in China, a lot of us in the private bar are doing those cases, and I agree with what you said. So many of the merger cases now worldwide, you have to file in the US, you have to file in Europe, and you have to file in China. So all of a sudden, we're becoming, Chinese AML advisors, as well as in Europe and the United States. Treatment of SOEs, probably the most difficult combination of economic and trade and politics that you can imagine. Obviously, that issue is focused on China. Now, the governments in the TPP are now starting to talk about disciplines on SOEs, and China is not a member of the TPP, or at least it won't be for many years. But we all know that China is the real driving force on disciplines on SOEs. The bit that Professor Alvarez faced, the U.S. has bilateral investment treaties, BITs, with literally hundreds of governments. and China has multiple bits as well. But the U.S. and China are now starting negotiations over their own bit that will absolutely dwarf any other bit negotiation that the U.S. has ever had. So all of these trade issues involve China, and it's just fascinating to see this. You know, from the perspective of a trade lawyer, where 30 years ago China wasn't even mentioned, wasn't even in the conversation.
Could you say a word about the position of foreign lawyers working in Beijing and other places in China?
Difficult. There has been, and
It's difficult to say or difficult to be?
difficult to be. As you know, literally one of the pioneers in the practice, working at a hotel room at Beijing Fandian. We've progressed past that. I ran our Beijing office for a few years recently, actually the same time Ira was living in China. It's difficult for a number of reasons in China right now. Number one, the Chinese government has restricted access to the local bar for foreign law firms. When we hire locally trained and qualified Chinese lawyers who have the Chinese bar exam, when they join our law firms, they magically lose the right to practice Chinese law. Poof, it disappears overnight. So, I mean, that's a market access barrier. There's no question about it. Secondly, incredible competition. The Chinese legal market is oversaturated right now. There was a wave of Western law firms that went into China 5 years ago. We're all there now. We're all competing with each other. But I don't think that's the most interesting thing. From my perspective, the most interesting competition is from the rise of the Chinese law firms. There is a fascinating development in China. I do work in Korea, Japan, Taiwan, China. Only in China do you see the rise of these mega law firms. These are law firms with 1,000, 2,000 lawyers. They're aggressive, they're good, they're smart, they're very keen business developers, and they are a tremendous competitive force. And it's interesting, we just don't see that in other countries in Asia. And so I think all these factors make it difficult to practice law in China.
Thanks very much. Others who want to contribute here, we most welcome, or members of the panel. I know you've got to go. Do you want to say something before leaving?
No, I've just remained hopeful on the climate issue. And because this is the key to avoiding disaster for the world.
You bet.
And
Yeah. Peter Dutton from the U.S. Naval War College faculty.
Thank you, Jerry. Thank you for a great panel as well. I'm really impressed with the richness and breadth with which China is engaging the world, and the world is engaging China back. And there were some particular comments that I'd like to highlight. Professor Alvarez, in particular, when you said that China's acting like a great power, acting like the United States in many ways. You really see that in my particular field, which is international law and national international security. You see that very much. And Professor Fox, when you talk about China, I will paraphrase, but China has a gravitational pull all of its own, right? And it draws us all into its orbit in very important ways. But unfortunately, I think Professor Belkin has a point as well, which is sometimes we talk right past each other. Right? We say the same words, but we mean different things. So in the field of public international law, and in particular my field, the law of the sea, I observe that day in and day out. We use the same words, we talk past each other. But we're both behaving, frankly, like great powers, the United States and China, both behaving like great powers in doing so. And that brings me to the point about what, the question, Jerry, that you asked right from the very beginning, which is what is the role of NYU? What can NYU be doing in this regard? And I think there are two things. One is educating students. Obviously, this is what you do every day. But we have, I think, an opportunity in the law schools today to prepare the lawyers to begin to engage in the grand international discourse that has to be occurring over the course of the 21st century, because China has a gravitational pull and we all enter into its orbit inevitably. And therefore the relationships, the international law and the relationships that we engage in with each other will have to change. The rules that govern international conduct will have to change by the way our orbits interact, if you will. And so are we educating students in not just the fields that we've seen today, but the fields where things like space law, cyber law, arms control law, my area, law of the sea, areas where we're going to have to re-engage in the rule sets with China over time. And then the last point I'd like to make perhaps is that keeping the conversation thriving. I think NYU in particular has a unique role in that regard. Being located in the center of New York has benefits in many different ways, but one of them is it attracts the international community here. And you can be a forum, NYU in general can be a forum for this kind of extended, century-long conversation that we're going to have as we adapt to each other and deal with that gravitational pull that China and the United States will have for each other. So I hope continuing to educate and continuing to engage in the conversation is what NYU can position itself to be.
These recent mentions of the WTO on the one hand and the United Nations Convention on the Law of the Sea, UNCLOS, on the other, make me think of one point that's worth emphasizing, and that is the Chinese government is always capable of considering the wisdom of its previous choices and adjusting to new demands of the world as things go along. Before China entered the WTO, there were many people, based on the track record, who said they'll never accept the arbitration system within the WTO. China doesn't go to binding third-party decisions, whether you call it court or arbitration. But as was said by Professor Alvarez, China's entry into the WTO shows they do accept the system. They win some, they lose some, but they conform to their obligation to resolve disputes according to their treaty commitment. But with the law of the sea, so far, we're not witnessing that. As the students in our seminar know, the Philippine arbitration against China, brought in January this year, has not produced a positive response according to China's obligations, as many of us see them under the treaty. But China has thumbed its nose, looked the other way. And my hope is, over time, China will conform to its obligations, let the Law of the Sea tribunals decide whether or not they have jurisdiction according to the Chinese commitments. So that's important. There's someone here who wants to. Professor Atanasio. Yeah, didn't
Thanks.
see you, John.
Very good to see you, too. A wonderful panel. What my interest was partly, and I waylaid Dick Stewart on the way out, this recent development where local managers are going to be graded partly based on their environmental performance, not just based on their growth performance, is, some people think, is a real effort on the part of the party to try to get some control over the just absolutely catastrophic environmental situation. Those of us, people who have not visited China, have difficulty imagining how bad it is that you can't see across the street sometimes in Beijing. It's gotten a little bit better of late, the water pollution, et cetera. So what I'm wondering is, and Dick offered his observation of skepticism, is the party really serious? Are they really going to grade local managers partly based on their pollution, their anti-pollution control in their new projects? And is that going to be rated on a par with their growth performance, particularly when growth has dipped? I don't know, it's 7.7 or 7. I haven't checked the most recent number, but growth has dipped. And can China afford not to do that in light of their water and air pollution problems?
Of course, you put your finger on one of the most important questions for any reform in China, which is the so-called cadre evaluation system. How do government and party officials get promoted? How do they better their own lives? And does the government give them credit for the expanded manufacturing facilities they have added to their community? Or will it in the future give them more credit for improving the local environment? And that comes up with respect to every issue. And of course, the party is not a monolith. The party has to reconcile all these conflicting interests, not through our type of democratic forum, but through their type, which does require paying attention to the views of many people. And whose views prevail, of course, depend a lot on the politics. Also, you have the local central thing. The central agencies can give you very attractive pledges and security of expectation. But the local people are faced with their own reality, and they do what they feel like. Years ago, a Chinese friend said to me in a poem I only remember 2 fragments of, Gaoji Ganbu Shuohao, high-level leaders make nice statements. Shaji Ganbu Luan Gao, low-level officials do whatever they please. And this is a problem of centralism and a lack of federalism. Not that our federal system is at the moment any model, but there are many options. I don't know, Ira or Frank, do you want to add it, please?
Well, but actually, I have a question unrelated to the environment. Is that okay? Okay. I'd like to ask Professor Alvarez a question.
This is always trouble.
Yeah. If you have arguably the 2 leading powers, who we've heard a couple of times, or more than a couple of times, who are acting as great powers, and that means not signing any treaties, not paying any attention to the International Criminal Court and all the other things that make up the international law regime for the other countries. What does that mean for the structure of international law in the future? Does there have to be some way to get the United States and China to behave as medium-sized powers, or?
Well, I mean, there's different scenarios that could go forward. So a lot of folks are saying it's not a twofold great power rivalry that we're liking to see, but more a multi-level game where the BRICS are part of the show as well. So what you see China doing is in part working with the BRICS in terms of, for example, the efforts that I've mentioned to have rival forums, including now the possibility of a rival to the World Bank and the IMF for a reserve currency as well as a development bank. So what you might see is a group of countries, each of which does particular things better and care about particular things better. So that some are suggesting that Brazil and India might be better in soft power than certainly China seems to be at the moment.
Certainly in music.
But yes, that's one way of putting it. The other thing is, of course, that there is yet no rival militarily for the United States. So what we're talking about with China is a great economic power, so that you're still likely to see a great deal of issues being thrown to the United States when it comes to military power and reliance on it, including through the Security Council, so that when things have to be done militarily, there will still be a reliance on the West, and especially the United States. So I think it will depend on the issue as to which group of states will exert leadership, including through international organizations or through other forums, G8, G20, and it'll be different configurations of states dealing with different topics. Where the challenge lies is when you're talking about the global commons, when you're talking about something where everybody, especially the great powers, have to deal with, like climate change. That's and I agree with Dick on that. That's the biggest challenge that I see, because I don't see I don't see a small group of states taking care of that.
There's a very good article that I asked the class to read for today by a law professor from Xiamen, who was a guest of ours a year and a half ago, Professor Tsai, about great powers and the shifting power alliances, and where a rising China or a developing China, a peaceful rise China, there are various cliches used to sort of categorize what's been taking place, is making an impact. My own feeling is that China is perhaps entering a third stage. The first stage on international law was when China was excluded from the international community, 1949 to 71. The second stage has been the last 4 decades or more since China's entry, the PRC's entry, into the UN. Now we're facing the question, China having had this dramatic rise in the last decade particularly, are they going to be content with trying to play a role modifying rules as necessary within the game, or are they going to try to reassert the traditional Chinese position, at least in East Asia, where China was at the apex of relations among the East Asian countries? And people say, well, that's not only a resurrection of the Chinese tradition, it also resembles what the United States has done in the Caribbean and Latin America, et cetera. So we don't know. We're looking for clues. Maggie Lewis from Seton Hall Law School, she is my collaborator on a book we've just published about Taiwan's abolition of its equivalent of Laodong Jiaoyang, re-education through labor. Maggie?
And maybe the mainland will get rid of re-education through labor, though I guess we're not holding our breath based on recent announcements. But I think the panel's made a convincing case for why we should care about China's legal system. And then, of course, the next harder question is what can we do to effectively engage in China's legal or political legal system? And maybe that's the 20th anniversary Gelatt Dialogue for next year. But when I graduated from NYU a decade ago, it was the beginning of the Hu Wen government. And there were lots of hopes for change, which I think for the most part didn't come to pass. There was some good news, particularly criminal justice with death penalty reforms and some other, I think, positive developments. But looking now at the Xi Li leadership and what the challenges they're facing, of course, the huge environmental issues and not just air, but water shortages and water pollution, the corruption issues, where, yes, you have the prosecutions of Bo Xilai, now Zhou Yongkang is being looked at, but those seem more political than a sort of overarching, really rooting out corruption at high levels, and then economic reform issues. And so all this makes me think is, well, what are the students who are 10 years behind me? So I guess if you were late Qing era, I'm what, Republican era or maybe early liberation. But the students today, some will end up being law professors who will do what we do as law professors and go to conferences, but a lot of them are going to be doing very different legal jobs. And how can they effectively engage with China? When I first worked at a law firm in China in the late 1990s, it was enough that I spoke some Chinese, was interested in China, and was willing to live there. And as we just heard, the foreign firm situation, I think, is very different for sort of what is the career trajectory of non-Chinese lawyers. There's people I know working in China at NGOs. That's difficult. Particularly the climate right now is not particularly conducive to foreign involvement in anything that's seen as sort of spreading Western values. And I think the Shanghai campus is wonderful, although not the best place to learn Chinese. So we'll have to get them out. But I do hope as we think about what NYU can do to engage with China, think also at the same time very concretely about what pathways there are for the current students to build careers with China in a time, I think, where that's not at all clear how the most effective way to have foreign lawyers engage in a day-to-day basis with China. And that's a challenge which will continue.
Good. Professor Fox.
Right. Thank you. I want to go back to the conversation that Frank launched and Jose picked up on. And this is about engagement. And it's about engagement, though, on the economic level, rather than the meta-political level. And that's totally relevant because it's part of the same picture. But if you will permit me, though, it's micro in a way, because it's a story about how China is engaging in the competition area and how it's sometimes not. But this is a kind of grassroots engagement that is a model that can work in other areas. So in the competition area, there's actually a big world community. And the world community meets mostly in an organization called International Competition Network. And in the International Competition Network, there's an attempt to set standards of convergences, or at least to understand in a kind of cosmopolitan way where the laws will converge. And when I say cosmopolitan way, it would mean, if I could take an example, that China could not use its SOEs to get the economic power and to monopolize through the economic power. So that is relevant in that way. Peculiarly, China has not yet joined the International Competition Network, but it's engaging very much with the world in the economic rules and standards that are applied. It's engaging in several ways. In one way, it has its teams of people meeting. For example, there's a merger that involves EU-China. They will meet together. They will talk together about the same cases. In another way, they will talk about international standards, and they're talking about them actually with the BRICS rather than with the world. And there is a BRICS meeting, competition meeting next week in Delhi, which I will be speaking at, which is about this subject of the convergence, which means the engagement. So engagement normally means having rules of non-discrimination, and that is the cosmopolitan view, that you have rules that will apply, and you don't give favors to people that are from your own country. You don't try to get the Chinese, and they don't try to get the Americans when we're doing business in one another's countries. So I just want to talk about the economic networks as a way to see engagement in which China wants to belong. It actually has expressed itself as wanting very much to be seen as following world standards in a cosmopolitan way, even though it doesn't always. There are exceptions. But it very much is out front in saying, we want to be a world player. And of course, they pull back when they want to. But I think that the economic networks on a grassroots level can be very important in bringing China even more intricately into world rules.
Thank you. And I think we can't assume, of course, that the BRIC countries and China will always have congruent interests. Brazil, for example, and China have had a large number of tensions that have accumulated precisely because of economic cooperation that made many Brazilians fear that China was buying up their country the way we used to fear Japan was buying us up. And we're beginning to get that concern about China. But no, I quite agree. It's economics that has been providing a lot of the glue and can do a lot more in the future. Yes, just one second. Ira, would you make a comment, and then we'll recognize the professor over here.
Yeah.
Oh, sorry, I just wanted to respond to two comments. One about the cadre evaluation system and environmental protection. I'm not going to make a prediction about whether it's going to work or not, but I think the question shows an insight into the Chinese legal system. And we're a law school and we're lawyers and we focus on the law, but I think we've learned sometimes the hard way through legal reform projects that haven't worked out the way we thought, that cadres care much more about their evaluation, their personnel evaluation, than they do about legislation or statutory law. Law in China is often enforced very weakly, but the cadre evaluation system is enforced very strongly. So, and those who have been studying about Chinese law, Carl Minzner in particular at Fordham has written about the importance of cadre evaluations. Alex Wong, who's a graduate of this law school, now at UCLA, has also written about it in the context of environmental law. And I think this is an insight that we can get from studying the Chinese system. And without that study, we just wouldn't be aware of it. So that was one comment I wanted to make. Another, we've had some discussion about career paths, and Maggie raised the question, and I want to bring in the role of government lawyers, which we haven't talked about much. Nason Mahmoubi from Penn, who's here, and I were invited to a group of U.S. government, an informal meeting of U.S. government lawyers last week, and we were asked to talk about changes at the Supreme People's Court in China. I'd say there were maybe 40 lawyers from different agencies, and there were probably, had there been a notice sent to a wider group, we could have easily had 100 U.S. government lawyers who deal with China in their everyday work. As a society, we don't really do a good job of training people for the needs that we have. I mean, these are all fine lawyers. Some of them I know very well. Very few of them have any training in Chinese language, Chinese society, or Chinese law. They're in these positions because they have jobs in those agencies, and they now have responsibilities that are important in dealing with China. And one of the things that we could do a better job of as a society is training the next generation of lawyers who can work in the U.S. Trade Representative's office. Not that they don't have good lawyers there, but in the State Department, in the Patent and Trademark Office, in the Department of Justice, in the FDA. Every U.S. government agency deals with China. And most of them now have offices in the U.S. Embassy in Beijing. And as a society that's based on the market and not based on state planning, we just don't do a very good job of training people for the jobs that we need them to do. So government service is another career path for people who are studying about Chinese law, and I hope that would be valued by those who, I know it is valued by people who are hiring folks in the government.
Yes, please, Professor.
Sorry, I'm Zhong Fan, a visiting scholar at Columbia Law School here. Thank you for organizing such a forum on Chinese legal issues now.
You're from Fudan University, aren't you, in Shanghai?
Yeah. My question will raise to Professor Everett. Yeah. Now, you know that the more and more products are produced in China, and we know that since 1992, there are many multilateral environmental treaties concerning protection of the environment, and there are many provisions on technology transfer in these treaties. But we know that there are fewer successful transnational technology transfer now occurring. Now we know that many the environmental sound technologies have been held by transnational corporations now. My question is, in your opinion, will the transnational corporation be the subject of international law? Now, if it is not, how to make the parties to the treaty to perform their obligations to promote technology transfer? Thank you.
Not my area of expertise, I'm afraid, but one of the issues that I would pick up on is if the part of the problem is the compliance with international treaties, then I think we're back to the problem that Professor Cohen raised, which is there is not a great deal to inspire confidence on either the part of the United States or China when it comes to complying with direct court orders from anything other than the WTO or investor-state arbitration. And so when you mention ITLOS, yeah, we can say it's a pity that China seems to be not cooperating with ITLOS, but not too long ago, the United States thumbed its nose at the ICJ when Nicaragua bought its case. So that when it comes to hard forums that would do the kinds of things you're talking about, neither country is likely to do that. Tech transfer, as you know, is a very sensitive question, including among our own multinational enterprises. And when you think about the treaties, you have to think about the groups behind them inside the United States. And where is the support going to come from to get those groups that were injured by tech transfer or feel that their bottom line will be injured by it, to support hard enforcement for treaties that include them? I'm not so sure that I agree there's been that many that actually have tech transfer hard obligations built in, other than suggestions that this would be a good idea, or softer notions of should rather than shall. So it's a combination of the lack of enforcement tools that both countries would likely agree with, as well as the soft way of tech transfer is usually put in the treaties. But again, I wish I had Dick Stewart to turn to an aid on that one.
I see some of our U.S. Asia Law Institute research fellows are now eager to get into the show here. Mr. Chao Shirtong, why don't you speak, and then Ms. Yin Cher will speak after you.
Thank you. I just want to follow up the question Professor Frank Upham had lodged. I mean, about the law and power in the international society. So the question is simple. Why do nations obey the law? Especially, why do bigger powers obey the law? I think Professor Fox has given an answer regarding the interactions between bigger powers in the economic sphere. That's because of, the network effect. Both the dominating power and the rising power, they want to participate in the network, of the interaction of the countries. That's, mutually beneficial. So they want to obey the rules. But I'm just wondering whether the same logic applied to non-economic spheres. For example, military or political interactions between countries. I think that's actually might be more crucial because even today, we have a very celebrated professor from Tsinghua University said that the whole world is going to become the two-pole world. China is one pole, and the United States is the other pole, implicating that there will be inevitable conflicts. So I think I'm just wondering how the international law and norms could, avoid these potential conflicts between the rising power and the dominating power, or could they? Thank you.
Well, this conflict comes to a head in the struggle over the rights of American surveillance, military surveillance ships and planes to conduct their activity without Chinese permission in the exclusive economic zone of China. We've had a couple of difficult crises over this, going back to April Fool's Day 2001 when a Chinese fighter plane crashed into an American reconnaissance plane, which then had to crash land in Hainan Island. And Margaret Lewis actually wrote a wonderful paper when she was a law student about that. And more recently, we've had others involving ships that were a problem. So this is not a theoretical question looking at the future of a rising China. This is a military-to-military question that the U.S. and China meet on repeatedly, and so far with no progress, really. Jose, you want to say something?
Well, I guess the two R's that work here when they work is reciprocity and reputation. And that does not have to be limited to economic affairs, so that we have lots of regimes where there's a sense of reciprocity, sort of ambassadorial immunities, for example, is one case, or even the extradition treaty that was mentioned. That is, people abide by them when you have those treaties because of the next case, you want the other side to cooperate the other way. That's a reciprocity-based idea. Reputation is the idea that once you breach one treaty in one area, people remember in the other area. So that does cut across sometimes outside of the economic zone. And I think that's the hope, anyway, that even when you don't have agreement on hard courts, you do have states that rely on the two R's or think that they have a real interest in making sure that they don't go across them.
We have time for one more question, and I want to ask Ms. Yin Cher. Ms. Yin, as a young scholar, just got her LLM here last year, but before coming here, had the unique experience for our students of having been a criminal court judge in China, in Chengdu, for 6 years. So her experience is invaluable, as is her assistant's.
Thank you, and thank you for the very informative forum. My question is regarding Professor Alberts mentioned one of the ways to get involved with the Chinese legal system is by academic exchange. So I'm thinking of the Shanghai campus. We know there's a very tight air in terms of liberal thinking in China. And how do we ensure our students or academic research in Shanghai can get out of this restriction in terms, for example, they can have access to the internet to the internet, like all the information they need to do the research paper, to publish the liberal ideas, academic papers in terms of our professors who are going to give lectures in Shanghai campus. They don't have to be concerned about those 7 prohibitions imposed by Chinese government. Like what should we do to protect our professors and our students? Thank you.
Oh, yes, I heard the question. So the question is, how do we ensure academic freedom issues in our Shanghai campus, including with respect to access to the internet? I wish John Sexton was on the panel, so he can explain what exactly is in those contracts with the Chinese government. Now, one concern, though, I would have is, let's assume for the moment that there is some sort of assurances, minimal assurances about academic freedom with respect to the Shanghai campus. There's a larger question at stake. Isn't it a bit odd if we have this little enclave of academic freedom just for us in the Shanghai campus? I find that a bit disturbing, even if it were to work. Now, I can't imagine, though, that it would work in the sense of total internet freedom for our students simply because they're our students, and that somehow they would walk around with this internet freedom card in their pocket throughout China. So I don't have any illusions that there are going to be very serious issues, even with respect to our campus. But I think there is a fundamental question about whether just preserving a little enclave for NYU Shanghai is really the best approach to this.
There's an analogous problem today with respect to economics. Shanghai has announced, as some of you know, a Shanghai Free Trade Zone. And people are discussing, what can you do within that zone? Does it mean a bank can set up a foreign bank and provide financing for a project outside the zone? If so, everybody in China will want to do that, all the foreign banks, and it won't be limited to this little zone, it'll be for the whole country. On the other hand, if they can't lend money for projects outside the zone, not many banks are going to want to be there. So it's interesting how these enclave questions come up. But it's not the first time. After all, in 1979, 80, 81, China set up its first special economic zones in 4 places. And they were experiments, but it was certainly clear to me and others, I think, that if they were going to succeed, it couldn't be limited to these 4 zones. Soon everybody in China wanted to have a special zone. Then the whole country became a special zone. So I think this is what's confronting the economic challenge. I'd like to think if we start with freedom for NYU's Shanghai campus, it could spread to the whole country, but I'm not betting on it. Well, this has been, I think, I'm party Priya, of course, Pianjenda, as we say, biased, but I think it's been a very good discussion. I want to thank our speakers for their revolutionary discipline and Chinese modesty, and I want to thank the audience for staying the course and adding stimuli to our discussion. So, as we say, wait till next year, but thank you in the interim.
Yeah, it does.